I'm going to direct my first question to Deputy Assistant Attorney General Jenny. As I noted in my opening statement, the Trump DOJ has adopted quite a novel interpretation of the False Claims Act. The DOJ now uses the statute to investigate federal contractors and grantees for allegedly defrauding the government by engaging in illegal DEI after pledging not to discriminate. You mentioned 3 areas that you work from the statute, but you did not mention this. But on February 19th this year at a Federal Bar Association conference, you gave remarks about the False Claim Act in which you declare, quote, DEI is a priority for us, and these cases are receiving expedited priority treatment. Scientists deserve to, end quote, scientists deserve to understand how you intend to use this tool of intimidation, even though in this committee you testified that you're primarily focused on foreign funds, data, and cybersecurity, but on February 19th you said DEI is a priority. Can you help me understand how grantees, well, excuse me, in the same remarks you conceded that grantees can operate DEI programs without engaging in illegal discrimination. Explain how that works.
First of all, let me just clarify. I focused on the 3 False Claims Act areas that I think or believe were germane to today's hearing. Obviously, our civil fraud section has a range of other enforcement areas, healthcare fraud and the like, that we spend a great deal of time on. In terms of the discrimination cases, I'd like to address 2 premises in the questioning that I think are not quite right. The first is to suggest that because this use of the False Claims Act is novel, that it's somehow infirm. And I think if you go back and look at the history and arc of the False Claims Act, it is a flexible tool. Congress intended it to be a flexible tool to rise and meet the moment as fraud, waste, abuse, lies against the government evolve. And so 30 years ago, you wouldn't have seen an anti-kickback statute False Claims Act case. 20 years ago, you wouldn't have seen an off-label.
Ms. Jenny, I'm sorry, we don't have the time to filibuster. I'm just asking you specifically, how do you see DEI under the False Claims Act and how it is that researchers can operate DEI programs without engaging in illegal discrimination or illegal DEI?
Sure. So the focus of our cases in this space has been on unlawful discrimination, violations of longstanding federal anti-discrimination protections. So we look in particular at the FAR regulation. It's 52.22226. It includes broad prohibitions on government contractors taking any number of protected characteristics into account when they make hiring or promotion decisions. And so when federal contractors expressly certify to the government that they are complying with that anti-discrimination protection, and then they nonetheless do not, that can be the premise, that can be a false certification to the government that can serve as the predicate for FCA liability.
And Ms. Jenny, so when you say that, how far is your look back period in these certifications and these hiring practice that you claim are illegal?
Our cases extend back to the full extent of the statute of limitations period, which can be up to 10 years.
So 10 years ago, preferential hiring was not illegal, but you're saying today you will do that, even though 10 years ago that was not the law. This was a executive order by the current president made just a little over a year and a half ago.
None of the cases we have ongoing right now are based
Ms. Jenny,
on...
that's not what I asked you. I'm asking you in the future because we have researchers who are concerned about their funding and being prosecuted, but you're saying you'll look back 10 years and perhaps may prosecute them for something that was perfectly legal to fit your vendetta against DEI.
I disagree. Our cases are based on violations of longstanding federal anti-discrimination requirements. The FAR provision that I cited has been in place throughout the...
So, Ms. Jenny, can someone operate a DEI program without engaging in illegal discrimination?
There's been some guidance out from the Department of Justice that gives examples of illegal discrimination. I think...
What are those?
Examples of illegal discrimination?
Yes, from their guidance.
Taking race or sex into account when making a decision on whether to hire someone, when making a decision on whether someone should get promoted, on whether someone should get an internship. That's really a core area of federal anti-discrimination protection.
So you're saying this is only going to be related to hiring but not programmatic DEI?
I think that programs can discriminate through DEI. They can also operate a DEI program without discrimination. The critical question is whether a program is making decisions based on protected characteristics, and the law has long forbidden that from happening.
Here's the contradiction that's raising eyebrows. At a Federal Bar Association conference back in February, Jenny, the Justice Department's top civil fraud official, told a room full of lawyers that DEI enforcement was a major priority for her division. She even said those cases were getting fast-tracked. But fast forward to her recent testimony before Congress, when she laid out her division's top 3 focus areas: foreign funding, falsified research, and cybersecurity. DEI wasn't mentioned once, not a word. Congressman Sykes had her February remarks right in front of him, and he put them directly to her on camera. Jenny's defense? She argued that the False Claims Act is a flexible, evolving law that's been used against new forms of fraud for decades. She pointed to an existing federal regulation, FAR 52.222-26, that's been on the books for years. The executive orders, she said, didn't create new law. They simply directed enforcement of obligations that already existed. But here's the moment that's getting the most attention. When Sykes asked how far back the DOJ plans to investigate, Jenny confirmed they're looking at the full statute of limitations, up to 10 years. That means universities and institutions could face liability for DEI hiring and admissions decisions going all the way back to 2015, years before any administration ever called them fraudulent. When pressed on what actually counts as a legal DEI program under the current DOJ view, Jenny struggled. She said programs must avoid making decisions based on protected characteristics, but that vague standard could sweep in many common outreach, recruitment, and mentorship efforts that universities have run for years, often with federal encouragement. The exchange ended with no clear resolution, and that's the real story here. Even the government's top civil fraud prosecutor couldn't draw a bright line between a lawful diversity program and an illegal one.